Good evening, and amongst us we have today V. Meenakshisundaram, advocate in Madurai Bench, Madras High Court. And he's also a resource person in the academies as well as otherwise also. He's very keen to take topics. But one topic, when we are connected with him, he said it's quite close to him regarding the claim petitions and obstruction petitions in the execution proceedings. As we all know that day in and day out, we read in various judgments that it's easy to get a decree, but to enjoy the fruits of the decree is a difficult task. To get into it, to understand as to how once you get the fruit, how you actually enjoy it, is the basic, the pith and substance of the today's session. And we are too glad that V. Meenakshisundaram, who is a young advocate, but full of knowledge, who has accepted our invite. Over to you, Meenakshisundaram. We are too glad that you've accepted our invite. Yeah, unmute.
Start. Yes. Good evening to one and all. Whether I am audible? Yes. Good evening to one and all. Today, I must start this discussion by giving two thanking notes first. First, I must thank the organizers to give this opportunity to present my first lecture, or I can say the first discussion class in this topic. Second thing, I know this is not an off topic for a Saturday evening. I know all my young friends are very busy and it is the only leisure hour in the entire weekend for an advocate, that knowing well, you all are ready to spend next few minutes with me on this topic. With these two thanking notes, I believe I can start this discussion session, and I request you all, don't take it as a lecture session, and it is only a discussion. And now I will start with this topic. Today's topic is claim petitions and obstruction petitions in execution proceedings. Why I have chosen this topic? Once an invite is from the organizers, why I have chosen this topic is for two main reasons. Now, the new era, or in this new era digital world, whether any changes or any amendments are necessary to this particular subject matters, that is claim petitions and obstruction petitions in civil litigation, particularly in execution side. That is the first thing always comes to our mind whenever we approach this subject. And second thing, why I have chosen this topic is, whenever this type of applications are filed, see, normally I start from the normal opinion among the law students is that they leave the entire 21 chapter, it is order 21 in their choice. If you come to a new entrant in the legal profession, they never have any acquaintance with the portfolio of execution side, even in the trial court. Even for seniors, they find it very difficult when they face these type of claim application and obstruction applications before the bench. And even in the appellate side, when the advocates in the appellate side, revisional side, file applications like CRPs and miscellaneous appeal as against these type of claim petitions and obstruction petitions, they find it very difficult at least to get a first impression before the bench about the case involved in this merits in this claim or obstruction petitions. And normally we are day in and day out, we are getting judgments that, as my learned friend said, in India, the real litigation starts only after obtaining a degree. See, normally I say, I discuss in a civil litigation, obtaining a degree or getting a degree is not the climax. I can say it is only an interval. The real film or the real villains, the real turn and twist starts only in the execution side. Therefore, these 106 rules in Order 21, and more particularly these claim applications and these obstructions applications, are very, very important topic in the execution side. Therefore, I have chosen this topic, and it is a discussion. Let us start this discussion. See, when we say it is a claim applications, immediately it goes back or it relates to attachments. And the claim applications are filed under Order 21, Rule 58. Normally, immediately, whenever we say there is a claim, it relates to attachments of an immovable properties in an execution petition, which is mainly filed with a degree for immovable property, or a degree which can be satisfied by attaching and bringing an immovable property for sale. Therefore, when we start discussing about claim application in Order 21, Rule 58, the first thing which we have to understand is what is the attachment in the immovable properties. If it is an attachment, then again, there is an attachment before judgment and an attachment in the execution side. Now, for a minute, let us take what are all the methods of execution regarding an immovable property, or to satisfy a degree like a money degree. What are all the methods therein to satisfy a degree through procedures in an execution? Let us start from that point. Normally, if an immovable property is taken for sale, it is only through an attachment, is our understanding. Whether it is completely correct, the answer is in Order 21, Rule 11, subclass 2. If you look into it, the execution petitions can be filed for attachment, or for attachment and sale, or a sale without attachment. Therefore, the main point is that an attachment is necessary only to have the satisfaction of degree, or to guarantee the degree holder or a plaintiff that if he succeeds, if it is attachment before judgment, if he succeeds, or in an execution side or in the execution stage, if he want to execute a degree, this attachment or availability of the property for satisfying a degree is the main process where an attachment is necessary. And the next important provision is Section 64, which speaks that any private alienations after an order of attachment is void. Always we stop that there, and we say that all the private alienations. But the section ends with these words: all such transactions shall be void as against all claims enforceable under this attachment. Therefore, it is not so that all the private alienations after attachment of the court, in attachment before judgment, or in this type of attachment in the execution side, is completely void. It is void regarding all claims regarding that attachment. This is why a person who got right in the property before attachment, or a person who got some interest in the property attached by the court, can file claim application under Order 21, Rule 58. I can say that it is a heartbeat, because always in a civil litigation up to degree, the court will concentrate only between the rights of two parties, plaintiffs and defendants. When the degree is put in execution, only in that circumstances how that degree affects a third party and how a third party rights can be adjudicated in the execution side. These are all very important, and one of that main important heartbeat section is provision is Order 21, Rule 58. If you look into that provision, it starts with the word Order 21, Rule 58. The heading says adjudication of claims to or objections to attachment of property. See, first I said that even an execution application can be filed for attachment or for attachment and sale or for sale without attachment. But this claim application Order 21 Rule 58 starts, it is an adjudication of claims or objections to the attachment of property. Why I am saying this is, this petition, first we have to look into the subsection when this application has to be entertained. What are all the circumstances when these applications can be thrown out initially? And what is the importance of this provisions which protects a right of a third party in having interest in this property which was attached by the court? Because section 64 read with Order 21 Rule 58, always these two provisions has to be read together, because 64 specifically says any alienations after attachment is void as far as all claims regarding that attachment. And if it's so, a third party who has some interest before or during or after this attachment can only apply under Order 21 and Rule 58 and get his right crystallized. And this is one of such important provisions. And if you look into these provisions, first, the more important thing is this application under Order 21 Rule 58 can be entertained only when the property attached was not sold in the execution proceedings. Therefore, 2158 application is not entertainable if the execution stage is after the auction in the execution proceedings. First thing. Second, there is a ground B which specifically says when this objection was designed for an unnecessary delay. This is a prima facie ground. By reading the objection applications or attachment application under Order 21 Rule 58, the court, even without sending notices or without hearing the other side, even by hearing the petitioner who has filed this attachment, can easily come to one conclusion whether it has been designed to unnecessarily delay the execution. What is unnecessary? What is the main theme behind this unnecessarily delaying designed? There are some illustrations. If a claim application is filed at the instance of a judgment debtor by a puppet person or through another person who is having no iota of interest, just without any evidence or without any prima facie right or a document supporting his claim, if he files an attachment claim application, then it had been rejected under these provision, that is under Order 21 Rule 58 Proviso subclass B. These are all two prima facie provision, prima facie thing which we have to first understand, that 2158 can be rejected on these two grounds even at the entry stage. Then, what are all the questions that can be decided under Order 21 Rule 58? The subclass 2 specifically says right all questions which includes right, title or interest in the property attached. Therefore, even if a iota of interest for a third party is there in the property, I can say to this level, this claim application can be filed even by a person holding an agreement, a legally enforceable sale agreement, who has given a substantial amount of an advance. Even though he is a person who is not having any title in that property, he is having some interest by giving an advance under a sale agreement. He is a person having some interest in the property. Even he can file an application under Order 21, Rule 58 to safeguard his right regarding this property attached as far as the amount which he has paid as an advance in his sale agreement. These are all a right, how the right of a third party to a degree is saved under Order 21, Rule 58 is one of such illustration. And such adjudication can be made. And orders, if you see clause number 3, it says it can allow the claim and release the property from attachment either wholly or to such extent as it thinks fit. Then the next doubt comes, what to an extent as it thinks fit? I will give an illustration. If a property is attached in an execution stage, a property of a judgment debtor is attached and a claim application is filed by a person who is having some amount of share in that property, and he is able to establish, even though it is a property purchased in the name of judgment debtor, the source for purchase is the family fund, and I am one of the family member, and I am also having some share in that property, and my share is quantified to this extent. Then to that extent, his claim or objection can be adjudicated, and to that extent the attachment can be lifted or it can be released. And that is why it says it can release the property from attachment either wholly or to an extent, such extent as it thinks fit. Next, it can disallow the claim or objection. I want to make a point at this level. If we all see the proviso clause to Order 21, Rule 58, subclause B, and this B, this B specifically said it has to adjudicate the attachment claim petition and it has to disallow the claim or objection. But even before adjudication, there is a clause which says it can consider it can reject if the claim or objection was designed for an unnecessarily delay. No such claim application can be entertained. That is at the initial stage. Even at the initial stage, under the proviso clause, the application need not be entertained. But after entertaining that application, after adjudicating upon the claim application or the objection application, even that application can be disallowed. These are all two stages where there can be a rejection and a disallowing or a dismissal. It is after adjudication. And the third thing is, subclause C specifically says it can continue the attachment subject to any mortgage, charge, or any other interest in favor of any person. This is more interesting. I will give an illustration how such an order or such an adjudication can be made, and such a result can also be there in a claim application filed under 2158. Normally, if a party comes to under this application before an execution court, And he says that I have obtained a prior degree, or I am a prior mortgagee, or it is a property mortgaged to a secured creditor, or there can be another application filed by a person who has already got a charge over this property. Whenever such applications are filed, it is not necessary for the execution court to release the property from attachment. Absolutely, the parties who have got prior mortgage, a secured creditor, a person who got a prior charge, or a person who already got a prior attachment, if they approach this execution court and file a claim application regarding the attachment made in the present case, then it is not necessary for the court, execution court, to allow that application and raise the attachment. It can pass orders under subclass C to the effect that this is the attachment which can continue subject to that prior mortgage. It can continue subject to that prior charge, because it is this provision is there only to adjudicate upon a valuable objections, and there must be a waiving parallelly the right of a degree holder who is also before the court, execution court, fighting for implementation or satisfaction of his degree. Therefore, if a person comes with a claim application with this particular types of claims, the execution court need not release that property from attachment on the ground that it is a secured creditor. It can pass orders that this attachment in this execution can continue subject to the attachment or the right of a prior mortgagee, or I can say that any person who got prior charge over this property. And the fourth ground is still more interesting. It can pass any such order as in the circumstances of the case it deems fit. It gives a wide power to the execution court under Order 21, Rule 58. What is such a wide power? What are all the circumstances we may think as an illustration? I will give an illustration on this point. If a claim application is filed by a bona fide purchaser in the execution proceedings wherein there is an attachment, and his bona fide purchase is absolutely after the attachment order in the execution side, then absolutely, as per operation of 64, his alienation as far as claims regarding the attached property is void. But there is a prior counter by the judgment debtor before the court, or I can say that there is some undertaking by a judgment debtor to the effect that he is having no intention for such alienations before passing an order of attachment, or he says some undertaking has been given. Then the court can pass any such further orders to maintain, not only to maintain or to sustain the order of attachment, but it can also pass any such further orders if the circumstances warrants, to save even the right of a third party who filed an application under Order 21, Rule 58. Therefore, it is a provision where there is a complete adjudication of a right of a third party or a title or interest of a third party towards an attachment in the execution side. And subclass 4 of Order 21, Rule 58 very specifically speaks that any of such orders which was passed under A, B, C, D of the subclass 3, then it amounts to as it were a degree and it is appealable. It specifically speaks where any claim or objection has been adjudicated upon under this rule, an order made thereon shall have the same force and be subject to the same condition as to the appeal or otherwise as it were a degree. Therefore, only, as I said in my earlier discussion at subclass 3, what are all the orders, types of orders that can be passed on the adjudication of attachment before attachment claim petition. The orders or the adjudication is a complete adjudication of a right of a third party regarding an attachment, and the degree holder right for getting satisfaction of the degree and the right of the judgment debtor in the property attached. Therefore, it becomes a complete adjudication, and that is why subclass 4 specifically speaks it has an effect of a degree, and it is a degree which effect of a degree, and it is an appealable order. That is subclass 4. And if we come to subclass 5, the proviso, that is why I have insisted that it reads where a claim or an objection is preferred and the court under the proviso to subrule 1 refuses to entertain it. There is a great difference of disallowing or dismissal under subclass B of class 3 of Order 21 Rule 58 and refuse to entertain under proviso class B of Order 21 Rule 58. There is a great difference. That is why the importance comes to subclass 5, where a claim or an objection is preferred and the court under the proviso to subrule 1 refuses to entertain it. The party against whom such an order is made may institute a suit to establish the right which he claims to the property in dispute, but subject to the result of such suit, if any, an order so refusing to entertain the claim or objection shall be conclusive. This is how it has been, the legislature started fit very wisely even at that point of time. If an application is filed under this provision Order 21 Rule 58, the execution court comes to a conclusion that it cannot be entertained even at the initial stage. And it said it was designed to unnecessarily delay the execution, and it rejected the adjudication process itself. Then the remedy for such a person is to file a separate suit. The remedy is not closed. He can file a separate suit for adjudication of his rights, and this rejection, initial rejection under 2158 subclass 1 proviso, subclass B, will not come in the way of filing a separate suit to adjudicate his right. And this order of rejection becomes conclusive only subject to the result in that suit. So this is how Order 21 Rule 58 becomes a complete code by itself regarding the claim of right, title, and interest of any person in the property attached. And I can say that it is something like a whole episode more than a suit. That is how it is very important at the stage of execution. Now, let us have a minute discussion or a minute thought whether this provision needs a change. See, why I insist for this thought process is a normal opinion among the entire judicial field is that every application in the execution side is a stumbling block for degree holder. It is designed only to delay and to have a bad impression upon this civil litigating system. This is how the opinion has been developed in this past, I can say, 25 to 40 years. But we look into this, and if we have the entire discussion on this 2158, I can take you to various provisions regarding entire 106 rules. But if you read these 5 subclasses of 2158, I can say it is a complete code by itself. It is having such a protection and such a great vision to decide or to have an adjudication of any person who claims right. For example, I will also put it in this way. We have come across a very latest many enactments in many other fields. For example, I will take surface. If you take surface is a complete code by itself, and it was come into force. It was introduced only for a very quick disposal of a commercial litigation with PAC. When there are high pin NPAs and then there is a great recovery problem in that side, it affects the entire nation and it affects the development of the nation, and that is the vision for which the Sarfazi Act has been enacted and was introduced. Even now, my dear friends, if you look into Sarfazi, if you look into the process of auction in Sarfazi, even the essence of these provisions are there. Even these type of applications are now entertainable, or it is there are provisions in Sarfazi to have a claim in the property which was there brought for sale. Therefore, 2158, according to me, it is a very important provision in the execution stage, and without this, an execution of a degree will result in great injustice to a third party who is completely not aware of this litigation. See, always we come across the civil court degrees or judgment or degree in personam. Only when it is put to execution, when there is an attachment, when it comes to a limelight or having reflected in EC, or when it comes for a delivery to the actual present field, the third party who is there in possession, or a party who is having a valuable right, or a party who is having an interest in that property, will get knowledge of these proceedings, and these provisions are the correct provisions wherein their right can be adjudicated. And it is, I can say, these provisions are by it is, I can say that it is a complete code, and it gives redressal of grievance of the entire third parties who claim rights. And that is how the legislature thought it fit to give discretion even to assess whether such a claim application is entertainable even at the preliminary stage. That is how the discretion has been given. Therefore, if the execution court strictly follow these norms and go by these provisions, there will not be any delay, and real justice will be rendered in the execution side on this process. Even a claim application is filed in the property attached for a satisfaction of a degree. And the next important provision is 2158 capital A, which specifically speaks that the reflection of any order passed for attachment or for raising the attachment or releasing a part of it, any order passed, that has to be reflected before the registering authority, putting the entire world on a public notice. That is how 58A is very much important. It is an amendment which was made in the year 1987. Therefore, this is the introduction of a claim application. And I can say the next important provision, if you look into 58 up to 60, there is complete, it is a complete code where it answers all the circumstances. I can say it answers all the circumstances where these claim applications are filed. And next important topic is the obstruction applications. I can say it is a lengthy topic. Both this obstructions and claim application in the execution side is a wide topic. When we go into it, it gets more deeper, and there are many minute points for discussion. Therefore, I take this first opportunity to have an introduction to all the persons here in this platform to have a discussion. See, this is not the correct impression about the claim application in the execution side. And I want to discuss and break that image or opinion. That is how I have taken this topic, and I am making an attempt to that effect. If you look into the following provisions after 58, which speaks very minutely when a sale can be stayed, when such applications are filed, and even if you look into that, the process of making proclamations and everything, it flows when a claim application is filed, and if the court feels, if on another side, if the court proceeds with the auction of the attached property, the person who comes with the claim application, his rights, even if he is going to succeed in the end of the adjudication, if the property is sold simultaneously, it will affect, and the third party right will be created. And that is how Order 21 Rule 59 was enacted, and it is also a more important provisions. Now let us come into obstruction petitions. The word obstruction itself is having some negative energy. Obstruction. I can say it is one another important provision in the execution side. Order 21, Rule 97 up to 105. Again, it comes as a complete code. If you look into these provisions very closely, I can say it is another full code having a full match. It decides the rights. And I can say that 21 Rule 97 interestingly starts with the word giving right to the degree holder who armed with the degree for delivery, or any person who got right in the execution proceedings, or a purchaser under the execution side go and gets for a delivery. If he was obstructed or resisted, he can come back to the court and he can complain that he is having such obstructions and get the help of the court to remove that obstructions. This is how the wordings of 9127 starts. For a minute, I will read 9127 and how it has been given a different interpretation, how it has there been a march of law for the past 30 years in this field. It starts with the word 97. Rule 97 of Order 21 starts with the word where the holder of a degree for the possession of an immovable property or the purchaser of any such property sold in execution of a degree. There are two class of persons. One is the holder of the degree, or the person of purchaser of such property sold in the execution of the degree is resisted or obstructed by any person in obtaining the possession of the property. He may make an application to the court complaining of such resistance or obstruction. This is Order 21, Rule 57. Actually, it is a complaint given by the degree holder or a purchaser who got right in a property in the execution proceedings, going for a delivery of the property. If he was resisted or obstructed in the process of taking delivery, it can be complained to the execution court and he can pray for removal of resistance of such resistance or obstructions. Let us now get into what is this process. How there will be a complaint. See, always in a practical point of view, if there is an execution warrant or delivery warrant, if a court opinions go there for an execution or a delivery of that warrant. Normally, if it is a judgment debtor who is there in the possession, he will lock. It will be the normal advice. He will lock the premises, or he will have some other persons there to obstruct, his own servants there to obstruct, and he will obstruct the Amin. And the Amin will come back to the execution court, files an Amin report saying that it was door locked or it cannot be taken delivery because of the judgment debtor's servants obstructions, and he will seek for police protections and other VAO help and surveyor help, etc. At this stage, why I am insisting is always in this side of execution, we skip this important process of Amin's report. We take it very lightly, and we pass on with that it is just a report, which will have an automatic order of police protection, automatic order of break open and everything. Why I am insisting here is, it is only based upon the Amin's report, the execution court prima facie at the first instance get the knowledge what is the resistance for execution of the delivery warrant. And there comes the importance of the Amin's report. If the Amin specifically make a note that it is a resistance by a third party, and he claims such and such right, and he is obstructing the warrant of delivery of this possession of this property, that becomes the prima facie first report before the execution court to get the knowledge of such resistance. Even without waiting for an application from the degree holder side, by perusing the Amin's report, the court can issue notice to such a third party obstructor and ask him to come to the execution court and answer what is the merit of his resistance or objections or obstructions in the execution of this delivery warrant. That is how the Amin's report plays a vital role at this execution stage. Nowadays, at passage of practice, I can say that it becomes a very lighter when it becomes, we allot these jobs to clerks, our clerks, and they are taking note of all these things, and applications are filed in the typed format. But it becomes more important. And the march of law in this particular provisions went to an extent that it is not only a degree holder, it is not only the purchaser who got right in the property of a property sold in the execution. Even the resistant party or the party who obstruct the execution can come and file an application saying that I am the person obstructing this delivery warrant, and I am having a merit in my case for obstructing this delivery warrant. And he can put forth his valuable claim, and it can be get it adjudicated under 2197. I must quote one interesting latest judgment which says a third party who is in possession cannot file an application under this provision 2197, and such application need not be entertained. A latest judgment, please take note of it, 2022 4 CTC 278. It is Sri Ram Housing Finance Limited versus Omesh Mishra Memorial Trust. It's specifically on this point. And it specifically speaks, the provision particularly gives right only to the degree holder. And it is only a complaint for removing such a resistance or an obstructions. And therefore, a third party who is there in possession and who is obstructing such delivery cannot file such an application. With great respect, it is Honorable Supreme Court judgment of latest judgment. I can say this judgment has not referred many other previous judgments, and I quote these two judgments for your kind consideration of all the viewers. Please read these two judgments, which is having a contra view. 1998 3 SCC 723 and a very latest judgment after this 2022 is, which speaks about the right of parties who can file applications under this provisions 2197 even before obstructing the delivery or even before removing them from the possession. The judgment, latest judgment is 2023 3 MW1 Civil 117. It is a latest reported judgment of Honorable Supreme Court, maintainability of obstruction application even by a party who is there in possession claiming independent right under Order 21 Rule 57. If these two judgments are considered along with 2022 4 CTC 278, that is Sriram Housing Finance judgment, we can easily come to a conclusion. 2197 can be filed even by a person who obstruct the execution or the delivery of a property. And now we come back to the provisions, because this is the march of law which I want to discuss with you all, that even though the provision specifically speaks giving right or locus to two set of persons, that is the degree holder or a person who purchased the property in the process of execution, but it can be also filed the obstructor also. And the second important thing is the power of the execution court, even without waiting for a complaint or an application under this provision from a degree holder, even by perusing the Amin's report, if you get knowledge, prima facie information about the details of the obstructors, then it can issue notice and call for that obstructor to present what are all the merits in his obstructions. Again, these provisions have the next important orders for adjudication, as like that of subclass 3 of Order 21 Rule 58. Order 21 Rule 98 speaks about what are all the orders that can be passed when such application resistance comes from a third party or if a complaint by a degree holder under Order 21 Rule 57. 2198 starts upon determination of the question referred to under Order 101, Rule 101, the court shall, in accordance with such determination and subject to provisions of Subrule 2, make an order allowing the application and directing the applicant be put into the possession of the property or dismissing the application. Again, now the march of law under 2197 and the types of orders that can be passed under 2198, it specifically seeks it can make an order of allowing the application and directing the applicant be put into the possession of the property. It specifically have a connection regarding the march of law under 2197, which I discussed with you all. See, if the petition is going to be allowed, then the applicant will be put into possession of that property. Particularly, it speaks about the right of the resistor or the obstructor back to the possession of the property. And that is why, by giving an interpretation to this rule, there is a march of law even under 2197. Then applicant who is obstructing can also file an application, and the result of allowing the application, his application, will directly give the result that he will be back into the possession of that property, or his possession already there will be confirmed. Second part is it can dismiss such an application. So what I want to say is 2197, 2198 and 21101. If you read these three provisions, it specifically says it is a complete adjudication of a right of a third party who comes in the way of delivery. And the second clause, which specifically says, as it gives a discretion to the court, execution court in the adjudication of this obstruction application, is to pass any such orders as in the circumstances of the case it may deems fit. And an illustration for such occasion to come is that if the party who is obstructing that is a tenant and he is obstructing the delivery of that property to an extent of his right of tenancy, then the conclusion of this application, obstruction application, may to the extent of removing him and put the degree holder in possession, equally saving his right of tenancy, his right of advance, his right of atonement of tenancy, even by the degree holder who comes forward with the application or to take delivery. So such types of orders can also be passed when such resistance or obstructions are there. For an example, if the tenant is there, he obstructs the delivery, the degree holder complains about that obstruction, or a tenant by himself he files an obstruction application for delivery of such immovable property, then the execution court can adjudicate upon that application and pass any such orders in the circumstances of the case deems things fit. He can pass orders if the degree holder who comes forward can atone his tenancy under him by getting more amount of rent or with additional deposit. Such an orders can be passed by recording a symbolic delivery and giving a right of tenancy, a new tenancy. Or he can be removed from the possession and degree holder can be put into the possession by passing an appropriate order of protecting the right of a tenant at least to an extent of his advance amount. See, such orders can be passed even under this obstruction application, and such powers can be given in Order 21 Rule 98. And the second provision is more important, where upon such determination, the court is satisfied that the obstruction or resistance has occasioned without any just cause by the judgment debtor or by some other person at his instigation or on his behalf or by any transferee. Please make an emphasis of the word any transferee because it have a direct link with Rule 102. Where such transfer was made during the pendency of the suit or execution proceedings, it shall direct the appellant be put into possession of the property and the applicant is still resisted or obstructed in obtaining possession. The court may also, at the instance of the applicant, order the judgment debtor or any person acting at his instigation or on his behalf to be detained in civil prison for a term which may extend to 30 days. See, why I insist upon this provision is, keeping aside for a moment, now let us come to 102 for a minute and come back to this Rule 2 of Order 21 Rule 98. Rule 102 specifically speaks, these rules are not applicable to transferee pendability. It reads like this, nothing in Rules 98 and 100 shall apply to resistance or obstruction in execution of a degree for the possession of immovable property by a person to whom the judgment debtor has transferred the property after the institution of the suit in which the degree was passed or to the dispossession of any person. See, this particular Rule 102 specifically bars, and the explanation clause specifically says transfer includes any transfer by operation of law also. It specifically bars such an obstruction cannot be made by a transferring penalty by the judgment debtor. If you read subclass 2 of Order 90 or Order 21 Rule 98, it also specifically speaks about the obstruction if it is caused by the judgment debtor or any person at his instigation or any transferee from the judgment debtor, such obstructions has to be removed, and still if the objections continues, the execution court is having the power to detain them in civil prison without an application for to that extent, EP for detention in civil prison, even if there is no prior, such power has been given under subclass 2 of Order 21 to 98. And next important provision is dispossession by degree holder or purchaser. It is one other important provision which specifically speaks where any person other than the judgment debtor is dispossessed of immovable property by a holder of a degree. Why I am insisting is, as the March of Law specifically speaks, 2197 gives right even to a person who is obstructing. That March of Law comes only from 2199, but it gives a harsh step that if an obstructor is a third party and he is obstructing with some independent right, 99 speaks that he must lose the possession. He must give the way for the degree holder to take the delivery and thereafter apply to the execution court under 99 and prove his merit. And if he succeed, he can get an order as provided under sub-rule 1 of Order 21 Rule 98 that the applicant has to be put again in the possession of the property. The word applicant used under Order 21 Rule 98 subclass 1 is the person who lost the possession under 99 and he comes to the court. I have lost the possession in the delivery warrant and the property was delivered to the degree holder, but still I am having a valid merit in my obstruction. And if his merits in the obstruction is proved to be correct, and if his application is allowed, such order will make him again to put into the possession as provided under sub-rule 1 of Order 21 to 98. By giving this interpretation of 2197, 2198 subclass 1 and 2199, there is a march of law. Even before losing the possession, the obstructor can file an application under 2197 and get his right to be adjudicated. And that is why I insisted the Amin's report and in the process of taking delivery or reporting obstructions to the execution court is very much necessary. And that difficulty of losing possession or giving out the way to take delivery and thereafter come under Rule 99 can be avoided by a correct Amin's report filed before the court complaining what is the obstructions or at least to an extent of details of the identity of the obstructor. And next is more important is, I can say, Order 21 Rule 101. What are all the questions that can be decided? It gives a wide power to the execution court to decide what are all the questions that can be decided. And that is how I have made my presentation to this extent that 2197 up to 21105 itself is a complete code and it decides more than a suit. It gives an adjudication, it gives a result more than a suit adjudication and a degree between the party. 21101 specifically speaks, it can decide all questions, including the questions related to right, title, or interest in the property arising between the parties to the proceeding on an application under Rule 97 or 99 or their representatives and relevant to the adjudication of the application. I request all my friends, please have a look with an attachment objection application 2158, where also it specifically speaks about right, title, or interest of an objector or a person who is objecting the attachment. Here, 21.101 speaks about, again, the word used is right, title, or any interest in the property which is going to be taken delivery between the parties to the proceeding under 97 or 99. It speaks if the degree holder who won complaint under 97 or a person obstructing the delivery can also, those rights can be decided under 101, and it shall be determined by the court dealing with an application. And the next word is very important, not by way of a separate suit. Therefore, the emphasis is more there in 101. If it is not by way of a separate suit, the whole provision from 2197 up to 21105 dealing with all these rights in taking delivery itself something very equal to a suit proceedings. A person obstructing cannot file a separate suit. A degree holder who is obstructed by a third party cannot complain and cannot go for a separate suit. Everything can be done in this execution stage, even under 2197 and up to 21105. Next important provision is Rule 104, which specifically speaks that the order made under these provisions on the adjudication of these obstructions application is to be subject to the result of a pending suit. See, that is how these provisions answers all circumstances. It answers all the circumstances. 104 specifically says every order made under Rule 101 or 103 shall be subject to the result of any suit that may be pending on the date of commencement of these proceedings in which such order is made. And if in such suit the party against whom the order under Rule 101 or Rule 103 is made has sought to be established a right which he claims to be the present possession of the property. See, for an illustration, if a third party who stands in the way of taking delivery, who obstruct the delivery, has filed a separate suit proceedings already as against the judgment debtor, and that is there in the adjudication process, and the degree holder in the present suit comes for the delivery, the obstruction application, in this obstruction application, for an illustration, the obstructions found to be no merit, and the obstructor was removed from the possession, and the degree holder was put into the possession in the process of execution or delivery of an immoved property. But at the instigation of at the initial stage of this obstruction application, and the independent suit is pending at the instant of the very same obstructor as against the judgment debtor in this suit, he failed here to prove the merits, or his complaint about his independent right was considered and dismissed. But in that suit, he was able to succeed. This result is subject to the result of that suit. And the suit has to be pending on the date of the initial point of these proceedings, because the previous rule specifically speaks such right cannot be ventilated by way of a separate suit when it founds an obstruction in the process of delivery. So the independent suit which was there mentioned in Rule 104 is to be pending at the initial stage of complaining obstruction under Rule 2197 or 99. Therefore, if such suit is pending, this result is always subject to the degree going to be passed in that suit. If there is no suit is pending, the obstructor cannot file a separate suit. He can only ventilate under these provisions. That is why in the initial stage of this discussion, I said that 2197 to 105, 2158, it is a complete code and it cannot be revisited with any amendment. I can say that even under 76, 2002, there are amendments to Order 21 only to make it more strengthened or to have a transparency. And there is no great change or there is no more amendments under Order 21. It has not undergone a great change even from 1908, even after amendment in 76 and 2002. That is how it becomes more important in the process of execution stage. And my humble opinion is 2198 claim applications and 2197 to 105. These two chapters mainly decides a grievance of a third party out of the game because he was not there in your game up to the process of getting degree. If such third party rights are having merits and if they are relegated to a separate suit proceedings, it will lead to multiplicity of proceedings and cross degrees. That is how these provisions are enacted. And these two applications, which mainly concerns about the valuable right of a third party, is more important. And without this, the execution proceedings will lead to grave injustice. And I conclude this discussion class, and I thank every one of you to spend your valuable time in this Saturday evening. And it is only an introduction. In future, we will have an entire discussion in a very detailed manner regarding these two chapters. Thank you, one and all. Thank you.
Yeah, thank you. Avijak is checking out as to whether we have any question. There's only one question on the YouTube. It says, how a claim petition can be filed in case of warrant of possession. Yeah, you will have to unmute yourself.
Yes.
Yeah. There's only one question.
Yes.
How can a claim petition be filed in case of a warrant of possession?
If there is, that is how claim application can be filed in regarding the warrant of possession, even under 2197, that the property is ordered to be delivered. Then if you are having a valuable right, you can file a resistance application even under 2197 read with 2158. See, these two provisions mainly connected with the right of a third party claiming right in the process of taking attached process of the execution by sale, attachment and sale, and in the delivery of property. I will give some important judgments to the organizers to post it particularly on this topic.
Yeah. The next question is, can a third party file a claim in the execution of a partition suit?
Definitely. If the partition suit, the execution comes after final degree. And after final degree, if any third party, if you are not a transferring penalty as enumerated under Order 21 Rule 102, if you are having a separate right, independent right, because I can say that mostly if a third party property is included in a partition suit, and everybody will be happy in getting partition of a third party suit. Nobody will reveal that it is a third party property. Even that may happen. And there are circumstances where institutions are having prior rights and by getting a revenue patta, individuals will file partition suit among themselves and get a degree. In such circumstances, the parties who are having a prior valuable right even can file an application in a partition suit, and actually in the execution proceedings of a partition suit, it is only for a delivery of a final degree.
The last question is, what's the basic difference between Order 21 Rule 98 subclause 2 and Order 21 Rule 102?
The basic difference is the subclass 2 specifically, it includes everyone. If subclass 2 specifically says, if at the end of the adjudication of 2197, if the execution court comes to a conclusion, such an obstruction is made only at the instigation of a judgment debtor, or it is by a transferee from a judgment debtor, then it can remove that obstruction, even going to an extent of making an order to be detained in the civil prison to remove that obstruction. But 102 specifically speaks to reject initially if it is an application, applications filed by a transferee penalty. See, if a party comes and he says that I purchased the property only from the judgment debtor, but I am a bona fide purchaser. See, if it is a purchase pending litigation, even by an operation of law, that is an explanation clause to Rule 102. Even if he is a purchaser from a judgment debtor by an operation of law pending this litigation, such application can be thrown out even without numbering under 102. But 98 subclass 2 says, at the end of an adjudication, if the court comes to a complete conclusion that it is only at the instigation of the judgment debtor by a transferee, then it can go to an extent of removing that obstruction even by making an order of detention in a civil prison.
This is whether an application for execution petition can be reopened in a case where satisfaction of the execution has been recorded by the executing court.
Definitely. That is why if you see, even after recording the delivery, that is why please read 99. Rule 99 specifically speaks that if there is an obstructor, but the Amins files a report that delivery was taken, it is a wrong report, and go by that the delivery, the execution court recorded a delivery and closed the EP, then the obstructor who was there in the possession or who was thrown out illegally by the Amins report come back to the very same execution court and complain that my obstructions was not duly noted and I am having a merit in my obstruction. The recording of delivery by this honorable court is wrong, and he can file an application and get his merit of this obstruction to be adjudicated. Even 99 speaks about an application after losing the possession.
So thank you, Meenakshi, for sharing your insights.
Thank you.
We're happy, and the way people have loved it on the YouTube, I'm quite sure that this journey will keep on coming. Thank you, everyone. Stay safe.
Thank you.